at the scheme of our constitution, okay, the provisions of constitution has protected individual citizens of the country against the state. State means state government or central government or state government bodies, central government bodies, government money machineries in general. Okay, why? Because every individual who is a citizen is also a consumer. All right, so if the consumer is not given a protection, they cannot stand the might and power of the institutions, for example bank, financial institutions. Okay, that is the reason even in constitution we have fundamental rights, protection of our fundamental rights. This is on the one part. Now let us come to the borrowers. Now I have seen plenty of cases, majority of the time borrowers do not have the agreement that they sign along with the bank, that loan agreement copy they don't have. This is a very, very wrong practice which is going on across India. There is no exception to it. I have not seen till now, whatever disputes have come to me, when I ask my clients that where is your loan agreement that you have signed with the bank or financial institution, they say, sir, we have not got it. Or they say we have got a blank one. We have just, what happens is there is a practice. This is a wrong practice, absolutely wrong practice, and people are following it. That's very, very worrisome. What the bank executive comes to a house, if I am a borrower, okay, the bank says we will send our executive. So he comes to our house, he takes all the KYC documents, and then he asks me to sign on the blank loan agreement form at prescribed marked places. There will be 10, 12, 15 places wherein I have to put my signature. Entire form is blank. I put my signature without even asking him to fill up the form. And then he takes it with him, then he fills it up, and what he says, he promises to give me a copy of the filled form, which he doesn't give me, because majority of these executives who come, they are either on contract or they are sales executives. They have to complete certain target and numbers, so they are running around. And in the middle, what happens, even I being a working person or a businessman, busy person, borrower, I also don't bother much. After a few days I forget about it. And when a dispute arises, then comes this problem that, if I am for the borrower, he says, sir, I don't have any, copy of the agreement. It's very important to see what is written in your loan agreement, who writes it. These things are very important. And to be very honest with all the borrowers, every borrower must fill up his or her own loan agreement form. If he or she is not filling up, at least ask somebody else to fill it up, but at least compulsorily take the photocopy of the loan agreement form. That's very important, very, very important. And plus, now normally banks, what they do, when I go approach a bank for loan, okay, they give me a sanction letter, or nowadays there is something called as pre-sanction letter also. So in that, what they mentioned that so and so person, we have, we are happy to inform you that principally we can approve so much of loan depending on your financials. I'm just saying it in brief. It could be little more detailed. Okay. After they have given us this pre-sanction letter, then I submit all my documents. I sign the loan agreement and everything. But the rate of interest is decided, right? So when bank gives me a sanction letter or even a disbursement letter, okay, in that bank must mention the rate of interest, and that rate of interest will be charged as per fixed rate or floating rate. So these things every borrower must notice or must take into consideration before he receives the money into his account. But normally people are not doing it. This is the biggest mistake. When you sign the agreement, interest rate is decided even before you have signed, because once you sign the agreement, your EMI is decided based on the interest rate, loan amount, and the tenure of repayment. So interest rate is decided before you get the loan, not after you have got the loan. And plus, bank gives you a choice option whether you want the fixed rate of interest or floating rate of interest. Many people ask me, what is correct? Fixed rate of interest is correct or floating rate of interest is correct? I normally tell them, if fixed rate of interest is way below floating rate, then fixed rate is better. Otherwise, floating is better, because normally if you see, banks have a habit of charging higher fixed rate of interest and lower floating rate of interest. because lower floating rate of interest can always be increased,
Hmm.
but a lower fixed rate of interest cannot be increased. They
Right.
have said it fixed. If it is a floating rate,
Hmm.
then as per the change in RBI interest norms,
Hmm.
banks also change it. If the interest rate is increased, they will increase. If it is decreased, they will decrease. Another thing from the borrower side is to check all the correctness of interest rate, tenure, EMI that they are going to be charged, processing fees, all
Hmm.
these things. Plus one more very important thing which I would like to bring it to the notice of all the borrowers. I have got these kind of cases. All right. Now,
Hmm.
many banks provide approved project finance, meaning a particular builder's entire project is approved by the bank. And if
Hmm.
I, as a home buyer, okay,
Hmm.
approach that particular bank for getting loan for
Hmm.
to purchase a property in a particular project, which is being approved by the bank, then
Hmm.
I get the loan very quickly.
Hmm.
Processing fees also minimum, or many a
Hmm.
time they don't even charge processing fees. Why? Because the entire project has been approved by the bank.
Bank, right.
But one very important, see, I will keep what you call covering both the sides, borrower and bank lawyers. Okay.
Hmm.
Now, when any advocate who is representing the bank, okay, if
Hmm.
before giving a approved project finance to any project, builder's project,
Hmm.
okay, there is a title search, land title search is done, title
Hmm.
search and title certificate is given.
Hmm.
Title search is one very important factor which determines the correctness of the title of the property.
Hmm.
Many cases, what has happened, the building has been constructed, society is made, all right, the society has, the land on which society is standing has been transferred to the society members, okay,
Hmm.
cooperative housing society.
Hmm.
After a few years, it comes to the notice of the society members
Hmm.
that there was some big pending taxes on the land for the last 20-25 years, and
Hmm.
now that burden is passed on to the home buyers, society members. So these things are very important.
Hmm.
What is important is when any banking or finance advocate does
Hmm.
that title search, okay, he
Hmm.
should clearly check 712 extract. Now I am practicing in Mumbai. So here they call it as Satbara Utara. Okay, it is a land document which shows the chain of ownership of the land. Who's
Hmm.
whom does the land originally belong to? Whether that person has sold it to second or third party, whether there was any interest created on the land, whether there are any legal hires to the land, all these things. Now in Maharashtra, there is something called as land revenue, okay,
Hmm.
which is charged by the Maharashtra state government. All right. So if a particular land revenue is pending, which it has not been paid, then it can be always recovered from the current owner,
Hmm.
even if the previous owner has not paid it. All
Hmm.
right, even if the previous owner has not paid it, but currently whoever is holding the land, whoever is having the society over the land, on whose name the land is, he or she or the society will be responsible to pay the revenue. And land revenue cannot be avoided at all. They have got tremendous power under Maharashtra land revenue code. They can even get the entire society vacated to, if the society fails to pay the charges, land revenue, that is called. So these are very important thing for advocates point of view, that when you are doing title search, please
Hmm.
do it thoroughly. And whenever there is a title search of a land, it always should be done for last 30 years. The title check in the records of the revenue department or sub registrar office, that for that matter, should be done for last 30 years. That is mandatory. This will give you a clear picture whether the land is, clear title property or there is any litigation. So this
Right.
is about for the advocate. Now let us come to the borrowers. Now borrowers, while signing the agreement and everything, they normally don't look into the title search. What they do is, if it is a second sale, meaning if they are purchasing the property from another owner, earlier owner,
Hmm.
then they do the title search for 12 years. This is the normal practice in the market.
Hmm.
But there could be a possibility that if the entire land is in dispute, they may
Hmm.
not come to know about it.
Hmm.
In such case, sometimes bank try to, if they have got a claim, for example, in the entire building, bank has given loan to many flat owners, okay,
Hmm.
and the land comes into problem, then the bank tries to, take over the property. Now there is one case with me which is of Nasik, okay, in which the same problem had come. 14.5 crore revenue was pending on the land for the last 30 years. and somehow that particular revenue was hidden. It was not showing in the 712 extract of the land title documents. After the society members formed the society and the land was transferred to the society, collector sent a notice to the society: if you don't pay 14.5 crore, I'm going to evict the entire society members and take over the building and sell it in auction and recover our government's dues. But thankfully, I got a stay on that society, so 22 families have been saved from eviction. But see, here the question is, I'll be very honest with you. The builder is the defaulting party here. He is the crook. He did a shoddy job of not disclosing that revenue, and he did not pay it to the government. And what he did, as soon as the building was completed, immediately he transferred the society to the land to the society. Conveyance of land title to the society. The society became the owner of the land, and land revenue code says that whoever is the owner and having current possession of the land, he or she or the society will be responsible. But then I showed it to the court that it is not because of the mistake of the society members, it is because of the mistake of the builder or the fraud being played by the builder. So for his fraud, society members should not be penalized. So now that thing is pending, case is going on. People are trying to settle it amicably. Let us see. I'm hoping for the best. But see, these are the things which everybody should keep it in mind.